has poisoned me to him. And if you explain it to him, yeah, the last thing he wants to hear from me is numbers. It has to come from Beth. Can I see the offer? Well, there's a verbal agreement. When you see it, Jamie, she's not going to believe it unless she sees it.
You guys know we can hear you, right? Okay. Good afternoon, and let's get started. All right. So today we're going to talk about priorities and licenses, and the plan, the hope, is that today will be the only day that we talk about priorities and licenses. On the syllabus, we're supposed to spend a week on it. We've expanded the time that we spent on some earlier things, so we're going to cut this a little shorter. To be perfectly frank, I think that this is one of those topics where, specifically priorities, the discussion in Professor Owusu's book is too extensive. So you guys know that I have said on a number of occasions that one of the things that I like about Professor Owusu's book is that it has extensive coverage of the things that I think are important for you guys. This one, I think he gets a little in the weeds. And so you guys, there's a lot of stuff in the chapter on priorities that is not really necessary for you guys. But so let's sort of rattle through this and get this done and then move on. And the doctrine of priorities is an equitable doctrine. So we talked about, when we were talking about equity, we talked about the bona fide purchaser for value without notice. We also talked about how in a modern registration system, the BFP basically doesn't exist. But the doctrine is still good, right? If there is a legitimate BFP for value without notice, then the doctrine applies. But the BFP doctrine only applies to the buyer of a legal interest taking subject to equitable interests. So you have equitable interests out there that exist. Somebody buys the legal title, and if they are a BFP without notice, the equitable interest gets wiped out. Okay? But what happens when there's a legal interest? Okay, or the flip side, right? Somebody buys an equitable interest and there's a prior equitable interest. This is where the doctrine of priorities comes into play. The equitable doctrine says that first in time has the stronger claim. And there's a Latin version, and I don't care because none of us are Roman. But the book has it if you are interested, and probably there are cases out there and judges out there who care. So you should probably be able to look it up. But the doctrine is first in time has the stronger claim. So the doctrine of priority says that where you have competing legal interests or competing equitable interests, the one that comes into existence earlier takes the priority. Okay. So where does this come into play in the real world, right? If we talked about how in the real world, in a modern registration system, there's almost no such thing as a bona fide purchaser anymore. And this doctrine sort of relates to that. Where does this doctrine come into play? I will give you an example. If you have two mortgages, if somebody has gone out and acquired a purchase money mortgage for a piece of property, and then 10 years later, they have acquired a home equity line of credit, right? Perhaps these are not terms that are used in the Caribbean. If so, I apologize. But they have two loans, both secured by the same piece of property. And the banks in question each have a mortgage in place. Okay. Then our poor debtor goes belly up, becomes insolvent, has to start divesting in order to satisfy creditors. Which bank gets the property? Doctrine of priorities tells us the first one, the purchase money mortgage, does. Because the mortgage is two legal interests. Now, there are circumstances where the mortgage can be equitable. We're not covering mortgages in this class. That's a real property 2 topic, but there are circumstances where that happens. But in cases where both mortgages are legal or both are equitable, the first one takes priority. Okay? But there are, in addition to the circumstance that we talked about where the bona fide purchaser doctrine applies, there are other circumstances where equity sets aside the doctrine of priorities. Most of these are not going to be relevant for this class, but they are things that you need to be aware of as sort of more broadly, you more broadly think about what you're going to be doing in practice and what you need to know for law school. So these are things that don't matter for this semester, but matter for the future. Okay. So in cases of fraud, so if the earlier interest was procured through fraud, it does not have any claim to priority. Arguably, it should be extinguished, but that's a whole different issue that we're not going to talk about. Second, if the subsequent interest comes into existence due to reliance on a representation that there's no priority claim, the priority claim will be set aside. Okay, so if the prior claim holder said, oh no, I don't have a claim, you're fine, and then the subsequent claim came into existence, that prior claim holder cannot come back in and go, fooled ya, now I have a claim. Okay, that's what we mean by estoppel. The third category is gross negligence. Gross negligence. Boy, I wish I had an explanation for you as to what this encompasses. But the explanation in the book didn't make any sense to me. And Google didn't help. So we're going to keep thinking about this one, and I may come back in a tutorial or briefly in a lecture and sort of hit this in passing to give you an explanation. But for now, I can tell you that this exists, and I can't tell you what it means. Okay. The other two mechanisms where the doctrine of priorities doesn't operate, or it operates differently, is with registration. Okay, so we've talked on a number of occasions about how the bona fide purchaser doesn't really exist with a full modern system of registration. Similarly, if an interest is registered, it takes its place in the priority timeline based on the date of registration, not the date of creation. Okay, so the power of this is that if you register your interest, you step in line in front of anything that might be unregistered, no matter where it exists. The price is that you lose your priority based on the date of creation, and you gain a priority based on the date of registration. Okay. And the last area where priorities don't operate in normal ways is in what's called overreaching. Overreaching. And what overreaching does, this is a statutory mechanism that exists in certain jurisdictions where by complying with the conditions in the statute, and they vary from jurisdiction to jurisdiction, you convert any equitable interests in the land into an interest in the purchase money. So you sell the legal title to the land, you comply with the requirements of the overreaching statute, and the holder of the equitable interest ceases to have an interest in the land. They now have an interest in the purchase money. Okay. All right. So this is it for priorities. It's pretty straightforward for the stuff that you need to know for this class. There's a lot of complications and wrinkles and just a lot of mess out there, because there's a lot of cases where people have become insolvent and they've had multiple creditors all exercising the same claim. So there's a lot of doctrine related to how priorities work and when it doesn't. But the broadest of broad strokes is what you guys need for this class. So what questions do you guys have at this point about priorities? A couple of people off mute. You guys, if you guys have a question, go ahead and. Sure. Tiffany, this was the 10-minute recap, like literally, like I've been talking for 13 minutes. The 10-minute recap is this again. Fraud, right? If you go out and you forge a deed, okay, or you lie to someone to get them to sign a deed, okay, then the interest that you create through those documents is not going to be granted priority. So that's what we mean by fraud. Okay, sure. So priorities come into play when we have multiple claims for the same interest in property. Multiple claims for the same interest in property. So we have a mortgage versus a mortgage being sort of the most common version of this, because it is not uncommon for people to have multiple loans secured by the same piece of property. Okay. But you can have a situation where the same people are claiming, or where different people are claiming fee over the same property. Or you have a fee versus a life estate, right? Anytime that you have more than one possessory interest in existence, or even a non-possessory present interest like a mortgage, you have to determine the priorities. You have to determine who has the better claim to the property. Okay. Because if and when that property gets sold, you have to know who gets the money. Okay. Because equity is concerned about the beneficial interest. Okay. So equity, so this doctrine does apply if both of these are legal interests. Okay. But it's still applying the equitable principle and applying itself to the beneficial interest. Okay. So Nicole, does that answer your question?
Sure. Can you just go over that part where you were saying that it combines, it relates to both legal and equitable interests?
Sure. The issue is that the interests on either side of the conflict have to be the same. Either they both have to be legal or they both have to be equitable. But priorities operates the same way in both circumstances. Okay, in that the one that comes into existence earlier in time has the priority and takes possession of the beneficial interest. Okay, so does that help, Nicole?
Sorry, I'm getting muddled. When you say takes advantage of the, it's just, can you just break that down? Or use an example? I think if you use an example, I'll get it.
So the whole issue here is that this is all about what happens when the property gets sold. Okay. Now, there are circumstances where like if you have competing easements, priorities comes into play prior to sale, but we're not doing easements in this class. So for our purposes, priorities only apply when we're selling the property, because we have to determine which of these conflicting claims is entitled to the proceeds of sale and who actually has the power to sell the property. Okay, because if you have competing deeds out there, both creating a fee simple, then only one of these is valid. And only one of these people can actually sell you the land. Okay, so this is why the doctrine of priorities came into existence. And the doctrine says that the earliest in time controls the beneficial interest. Okay, So what that means is if we have these two competing deeds, right? And one was made in 1912 and the other was made in 1920, well, you better go and buy the land from the person who sold it to you who bought it in 1912. Because the person who bought it in 1920, they don't have anything. Okay. But the way that this operates sort of in the year 2020 most frequently is you have two mortgages and our homeowner or our landowner gets behind, winds up going into insolvency, and the banks that hold the mortgages have to figure out who has the right to foreclose. And the answer is the earlier one in time has the right to foreclose, seize the land, and sell it to satisfy the mortgage. The later one in time has the right to whatever's left over after the first one is satisfied. So Nicole, does that help now? Now that
Yeah.
now that it's a little more concrete?
So just a question which may or may not be relevant. In your example of the mortgage, so then what is the benefit of having, well, not the benefit, what is the rationale then for allowing that to, like, two mortgages on the same, backed by the same piece of land?
Well, so the answer for the bank is whatever their analysis of the credit risk is, right? They thought that the junior, right, the junior mortgagor thought that they would get repaid. They didn't expect to find themselves in this position. For the homeowner, what happens is the second mortgage is it's only really against the part of the house that's already paid off, right? So when we talk about a home equity line of credit, that's a loan that is secured by the portion of your first mortgage that is already paid off. Okay, and again, this may not be a thing that banks in the Caribbean do. They may not.
Got it.
So,
Thanks. Mhm.
okay. What other questions do we have about priorities? Once?
Yeah.
Everything okay over there? Going twice? Okay. Here's my eraser. All right. Now let's talk about licenses. First of all, what is a license?
A license is when you as a grant give permission to someone to sell alcohol. So it wouldn't be like an extended period of time that before it was completed. That makes sense.
Yeah, that's it. So for those of you who couldn't hear, a license is permission to use land for a particular purpose. Okay, and Travis is absolutely right that most of the time it's a purpose that is fairly confined in time. There are circumstances where that's not true, and we'll talk about those. But for the most part, that is correct. Okay. So there are four types of licenses. First one the bear license. No. The bear license is, yeah, Adrian, that's absolutely correct. The bear license is a license that you haven't done anything to get. Usually you don't even ask for it. It's presumed in sort of the part of, like, it's presumed because it's part of how we live. So like, the Postal Service has a bear license to come onto your property to deliver the mail. Okay. And unless you post like a big, a no trespassing sign, or you lock your gate or something, we generally assume that people have a bear license to come into your front yard in order to knock on your door. Okay. You can throw them out, but they have the right to come onto your property to see if you're home and to talk to you about whatever they want to talk to you about. Okay. Because there is no contractual relationship with a bear license, it can be withdrawn at any point. You can be like, get the hell out. And, you know, you can't call the cops 20 minutes before you tell somebody to get out so that they're waiting to cuff them when you tell them. But you can pretty much tell somebody to get out and be like, if you're not leaving right now, I'm calling the cops. So that's how a bear license works. Okay. Don't talk much about them because like there's not a lot to talk about. You know, it's interesting more in terms of like, what are the circumstances where it seems like this is likely to have arisen? Because that's sort of the puzzle is, what are the things that we look around and go, oh, this is perfectly normal, but actually it's a trespass? And the fact that we think of it as being perfectly normal probably means that there's a bear license. Okay. So what questions do you have about a bear license before we move on? Okay. This one's pretty straightforward, right? Pretty easy. The next one is a license consequent to an interest. What this means is that you may have an interest in land that requires you to be able to access the land. Okay. We haven't talked about these. They are not real property one topics, but things like the profit prondra or the usufruct, in certain circumstances, maybe an easement, although an easement is technically an interest in land that grants access. But if you have an interest in land that requires you to go on the land to make use of it, which basically requires you to have that interest by deed, then there's a license attached to it, right? If you have to be able to access the land to make use of the property interest that you have in it, then the property owner can't keep you off the land. Now, in order for a license consequent to interest to be irrevocable and binding on third parties, so if the property owner sells the property, for it to still be binding on the new owner, your interest has to be created by deed. Okay, so you have to jump through the hoops of creating a legal interest in land. Okay, but if you've jumped through those hoops and your interest meets the necessary requirement of being the right kind of interest, this sort of license is irrevocable. You have it for as long as you hold this interest. Okay? Yeah.
Can I get an example of that?
Sure. So the question was an example. So a usufruct is an interest in land that allows you to go on to the property and obtain like the agricultural fruits of the land. Okay, so you can pick fruit or gather vegetables or whatever, right? That interest by itself gives you no right of access. It's just a right to gather, but you've got to figure out how to get on the land. Okay. But the courts go, that makes zero sense, right? There's no reason why we're going to say you have the right to gather these crops, but you set 1 foot on this property and you are under arrest, right? That's pound of flesh stuff. Okay. And so the courts say, look, you clearly have a right to go onto the land in order to exercise your interest. But your right to go onto the land is not an ownership right. It's a license, right? It's permission. Okay, that is required for you to be able to make use of your interest. Okay, so does that help now?
So for something like postal services, would that be public license or the other one consequence?
Yeah, the postal service is going to be a bare license because they're not, you don't have any sort of contractual relationship with the post office. They don't own a piece of your property. I guess you might. Like in the United States, every mailbox you buy has stamped on it property of the United States Postal Service. I'm not sure I buy that. But that's consistent with sort of the particulars of how the Postal Service regulates mail delivery in the US and is not necessarily relevant to anything else. But so I would describe the post office as having a bare license, and so does Professor Cotolini. Yeah.
In the Caribbean, one example, like I really think that the instance the government owns parts of the land because of the minerals that may be there. So they have somewhat of a contractual license to go there to gather minerals.
So maybe a better example would be I'm sorry, say that again. Yes, they didn't mean to say it. I think a better example might be beach access. Okay, because we talked about, earlier in the semester, there's this sort of differential amount of how much of the beach is has a public access available to it. And okay, so I guess that was unintentional. So clearly, right, the public's right to access the beach is some sort of license. Okay. But is it a license consequent to interest, or is it a bare license? I don't think it's one of the other two that we'll talk about in a minute. I definitely think it's one of these two. Because there is an interest in land. Okay, it's held by the crown in the countries where the queen remains the head of state. It's held by the state in republics. But does the public's access right follow the interest in land?
Sir,
Yes, go ahead.
so with the postal delivery, is the implied assumption that you have you have, let's say, a contractual relationship with the postman, or you have a relationship with the postman in that you know he has to deliver your mail, and if he has to deliver your mail, then by right he needs access to your property. I'm just trying to see how in
So-
understanding beach access, what the
Yeah.
relationship would be on.
So you've described the postal carrier, the relationship you have with the postal carrier correctly, except there's no contract. Okay, you haven't,
Okay.
you don't have an agreement with the postal service for them to come and deliver your mail. They just do it. Okay. And so that's why it's a bare license, because there's no contractual component. There's no consideration that justifies the grant of the license. It's gratuitous.
But I mean, when you were saying whether beach access, which category it falls into, I'm just trying to distinguish.
Right.
Like you get
So-
mail, but what's the relationship
Yeah,
with
yeah,
the beach?
So with the beach, the issue is that there's an interest in land associated with it. But the interest in land doesn't belong to the people who have the right of access. Okay, so without the interest in land, there is no right of access. If you don't, we see in Jamaica, right? That where there's no crown ownership of the beach, that the public can be excluded. We also saw that in Barbados, but policymakers in Barbados pushed back against it and created a public right of access. So there has to be the interest in land for there to be the right of access, but the right of access isn't held by the entity that holds the interest. So that's why I say that beach access presents a puzzle that, you know, I'm not entirely sure there's a good answer for, right? In that, which of these types of licenses apply? And part of why there's not a good answer to which of these types of licenses apply is because it doesn't matter. It's the same right. Okay. The only difference lies in the revocability. But if the public's right of access is a bare license, the state is not going to revoke, the state that holds the interest is not going to revoke that right of access. If they do, you have a very different sort of problem. Okay, there's probably some issues of democratic backsliding, and they're trying to prevent assemblies on the beach and blah, blah, blah. So, but do we understand like how the license consequent to interest works now? That you have to have this interest in land, it has to be created by deed, and then it's irrevocable and it is binding on subsequent purchasers of the property. Right. So that much makes sense, even if the whole stuff about beach access maybe doesn't. Okay. So the third type of license is a contractual license. And this is the one that I'm sure most of you that you're most familiar with. So you buy a ticket to an event. You pay your dues at a club that gives you, a right of access. You do something that You pay your parking fee. You know, if you have a parking pass, okay? These are all contractual licenses. You live in the halls of residence at UE. This is a contractual license. Yeah.
Something like walls before the lease.
So this was a conversation that we had earlier in the semester, where I told you guys that I don't know what you guys sign with UE. But when I lived in dorms at my undergraduate, the documents that I signed were very explicit and very clear. This is not a lease. You are not a tenant. You are not entitled to the protections of the Landlord Tenant Act in this jurisdiction. This is a license to occupy that we may revoke at any point if you breach the contract. And so I say that jokingly about the halls of residence here, because again, I don't know what you guys sign. But it is entirely possible to basically be granted a license to live in a space. So this is why I said earlier that licenses don't have to be for brief periods of time. They can be for quite extended periods of time. Okay. So this is the contractual license. It is basically revocable at will. And if it is revoked, your remedies are contract remedies. Even if you're thrown out by force. So this is the Week versus Leadbittner case, where the gentleman bought a ticket to a show of some sort. I don't remember what the show was. And the proprietors asked him to leave. He refused to leave, and he was thrown out by force and injured in the process. And the court said, you have no claim for assault. Your injuries don't matter because you were a trespasser at that point, and they could use reasonable force to get you off the property. Your claim is for the breach of contract, in that they sold you this license and then they took it away. Okay. And it was, I think it was like a movie. So he was owed like a couple of bucks. So this went from being, a potentially very lucrative claim to, well, here's your $2, get out. But there are other things that you can do, right? Equity, that's the legal mechanism. Equity also plays a role with contractual licenses, and that's that equity goes, wait, you paid for this, and you paid to get access for this show or this event or this club, and it's not fair that you can just be thrown out and all you get is your money back. So equity will actually enforce a contractual license via injunction or specific performance. We talked about what those are, right? So the injunction is the order, thou shalt not revoke this license. The specific performance is, no, you just think you threw him out, let him back in. Okay? But wait, there's more. The contractual license is also used in equity to protect participants in family disputes. So people who live in family property but don't own it and don't have any sort of interest in the property, right? So we're talking, I mean, honestly, let's be very clear about who we're talking about. Overwhelmingly, we are talking about women who are in the process of trying to escape abusive relationships. Okay. And the courts have held that folks in these situations, usually but not exclusively women, have an irrevocable contractual license to occupy the property, even though they don't own it. And that is enforceable against subsequent purchasers. So your abusive husband moves out of the family house and then sells it out from under you. The court, sitting in equity, will require the subsequent purchaser to allow you to stay basically a year, right? So it's basically for a subsequent purchaser, it's reasonable notice, which is regarded as 12 months. Okay. So what questions do you have about a contractual license? Okay. Last thing. The license protected by estoppel. And as with all estoppel claims, this requires a promise and reliance to the detriment. So you got to have a promise, right? So, oh, sure, you can stay in this property, you can access this property, not a problem. And then reliance. So maybe I start moving my stuff onto the property, or I start planning to be able to have access to this property. And then you go, oh, no, I was a joke. You can't, no. Oh, you brought all this stuff? Oh, this is my stuff. What are you talking about? Right? So these are the cases where the courts will go, oh, no. No takesy backsies. Okay? You are estopped from withdrawing this license. Okay. So this has been your whirlwind 30,000-foot tour of priorities and licenses. What questions do you have about this? Okay. Going once. Going twice. What equitable principle allows persons to stay on a property? Abigail, you can put your question in the chat and we'll try and get to it as well. What equitable principle allows persons to stay on a property? I mean, I think it's the equitable principle for licenses protected by estoppel. The equitable principle is equity requires clean hands. So most estoppel claims basically sound in unclean hands. Like you can't do what you're trying to do because you've made promises earlier that prevent you from doing that. For the contractual license, I would say probably the equitable principle is that equity delights to do justice and not by halves. And so like, it's not fair that you don't get the benefit that you paid for, or that you're being thrown out of your family home for circumstances beyond your control. And so we're gonna protect you from that. So that would be the equitable principle that I would say. Okay. Sure, the license protected by estoppel requires the promise, reliance on the promise, to the promisee's detriment. So the reliance is by the promisee, the person who received the promise, to their detriment. Okay. Abigail, does that get you squared away? Okay. We're out of time. So if you have further questions about priorities or licenses, please don't hesitate to reach out. The estates redo is due on Sunday. The next assignment, which is on co-tenancy, there's a video on YouTube for it, and it is due on the 22nd. So I will see you guys next week. Take care and bye. It's the most recent video, which the most recent one. I haven't uploaded this week's lectures yet, so.